This virtual courtroom hearing shows a tense collision between sovereign citizen-style beliefs and the reality of the legal system. Appearing by video from the Dickinson County Jail, Drew James Pelto identifies himself as a non-citizen American national and references common law ideas, but unlike many people who take this approach, he actually has a defense attorney representing him. That creates an unusual dynamic as his personal beliefs run alongside formal legal representation. The judge keeps the focus on the real issues before the court, a misdemeanor disorderly conduct charge and a bond violation, while setting upcoming dates for a pretrial conference and jury trial. A key moment comes when the judge requires Pelto to sign a waiver of extradition because he travels between Michigan and Wisconsin, a standard bond condition that contrasts sharply with his claims about legal status. Bond is granted at $1,000 personal recognizance, but with strict rules. No alcohol or non-prescribed drugs, random testing, no entering bars, and no assaultive or harassing behavior. The most dramatic part happens near the end when Pelto, while trying to explain himself, blurts out that he's not even on drugs anymore, nearly incriminating himself before his lawyer and the judge quickly cut him off. It becomes a real-time lesson in how quickly courtroom words can create serious consequences.
Good,
thank you. How are you today?
Not too bad. Feeling a little rough, sore from being in a holding cell 3 days, but other than that, I'm okay.
All right, let me call your matter so we're on the record, please. People of the state of Michigan versus Drew James Peltola, 247819SM. Mr. Peltola appears from the Dickinson County Jail. Counsel at first appearance is Abby Anderson, who appears via video Zoom. And the prosecution is not here today of their own choosing. Mr. Pelto, before we went on the record, indicated he could hear me adequately, and he was all right other than being sore from being in the holding cell for 3 days. In respect to the matter, then, Mr. Peltola, I do have an advice of rights here with your signature. I do see it looks like the copyright insignia. I know that we have discussed the issue of the sovereign citizen in the past. Mr. Peltola, can you tell me what your position is today, please, after telling me what your full legal name is, if you would?
Okay, I'm an appellation known as, all capital letters, Drew James Peltola, with a common law copyright as a sui juris human, as a non-citizen, a non-American national. That's defined in the United States Code. I'd like to have my lawyer finish talking. She told me not to talk.
Go ahead, Ms. Anderson.
Thank you, Your Honor. I have discussed these matters with Mr. Peltola. First, he agrees to be referred to as Mr. Peltola for purposes of these hearings. We have gone over both the advice of rights for misdemeanor and bond violation. He indicated he understood and signed both. As to the allegations, we went over the maximum penalties. We would waive the formal reading. He is tendering not guilty pleas and requested an attorney. Ms. Mashik Lasala has assigned Nancy Schaub to represent him.
All right, very well. As indicated by Ms. Anderson, Mr. Peltola has agreed for purposes of his criminal prosecution to be referred to as Drew James Peltola. His position in respect to how he should be recognized legally has been stated for the record and is preserved for the record, as well as stated on the advice of rights forms concerning both the general misdemeanor advice of rights. Although the bond violation advice of rights doesn't so indicate, the court will recognize his position for purposes of both advice of rights. Concerning the matter, then, is this a good mailing address for you, Mr. Peltola, on River Street in Niagara?
Yes, Your Honor. I'm just trying to move back into Michigan, so I've been working, and that's the address that I use because that's my domicile. I always return to every day or once a week or whatever. Because the Michigan residents, I'm not even sure. I would not like to talk about that in court, but I'm trying to move back into Michigan. I'm just having a heck of a time doing it.
All right. So this is what I'm going to do then, Mr. Peltola. Over there, let's see if I have one in my file first. Ms. Anderson, I don't see a waiver of extradition. It sounds like he's gonna need to go back and forth to Wisconsin, and we'll address that momentarily. In respect to the matter, though, Mr. Peltola, there is a waiver of extradition form over there at the jail. I'm gonna have to have you sign that if you need to go into Wisconsin as part of this. In regard to the matter, then, what?
How do you want me to sign this? If you want my copyright, do you want me sui juris, just so you understand, like I wasn't trying to harm you or any other woman?
Go ahead.
Do you want my copyright on this? Do you want me as a human or me as a sui juris non-citizen national?
I just want your signature and the date, and whatever you want to put in addition to that is fine with me.
All right, thank you, Kim.
While Mr. Peltola is signing that, we did discuss the waiver of extradition. He just wanted that answer clarified prior to signing, but he is aware of what the waiver of extradition is.
Very good, thank you. All right, I'll enter not guilty pleas on behalf of Mr. Peltola. Ms. Anderson indicates that he's qualified, and he is being assigned by MIDC. Ms. Schaub, we're going to set bond violation hearing. We might as well do the pretrial at the same time. And a jury trial as follows.
You want the jury trial within 20?
Yes, just to be safe.
Okay. Pretrial conference and bond violation hearing on February 21st at 1:45 p.m. Jury trial March 8th at 9 a.m.
All right, you'll get these dates in writing, Mr. Peltola. In respect to the waiver of extradition, then I want to go over it with you briefly as well.
All right, cool.
In
I can
respect-
wait. You want me to stop filling this out?
Really all you need to do, yeah, go ahead. You finish and then I'll go and then I'll talk. You let me know when you're ready.
I'll just sign it real quick on the bottom of it and they can take care of the rest of it. I'll sign it properly. The bottom law might be wrong. It's been a while since I've read the Unified Court, but I believe this is right. I signed it for you correctly. So.
All right, perfect. All right, if you give that to the jailer, Mr. Peltola, I want to go over with you what it means to sign that waiver. I know we've done this before, but I'll just refresh your memory. And let me start by saying, so long as you come back to court voluntarily for all your court appearances, this does not become relevant. But if you don't come back to court, let's say, for example, you stayed in Niagara or somewhere else like that, normally you're entitled to what's called an extradition hearing before you are returned to Michigan to fight the charges that you didn't come back to court for. Yes. Under an extradition hearing umbrella, you have the right to an open court hearing. You have the right to have a lawyer at that hearing. And if you're indigent or without funds, one is assigned for you. The purpose of an extradition hearing allows you to challenge the legality of your arrest and return to Michigan. For example, you could demand issuance and service of a Michigan governor's warrant for your arrest. You have the right to obtain a writ of habeas corpus. Like I said, all to challenge the legality of your arrest and return to Michigan. When you sign a waiver, what?
I said I won't resist, man.
I'm just explaining to you what that document is that you're signing, okay, for the record. That's all. I'm not suggesting, implying, or anything else. I'm just explaining, all right?
Thank you.
All right. So when you sign that waiver, then what that means is, and like I said to start with, so long as you come back to court, everything is hunky-dory or everything is all right. But if you don't come back, when you sign that waiver, you have given up your right to that type of a hearing that I just explained. Do you understand that?
Yes, Your Honor.
All right. So that's what that means. So when I'm setting bond, I need that form back because I'm going to do the following in respect to your bond. And this can cover both the bond violation and the underlying charge of disorderly. All right. First off, you must sign a waiver of extradition as a condition of your bond. So long as you do, you can go back and forth between Michigan and Wisconsin for residency, court appearances, family visitation. If it expands beyond that, talk to your lawyer first, okay?
Yes, Your Honor.
All right. You are not to purchase, possess, or consume alcohol or non-prescribed controlled substances. You must submit to random PBTs and drug screens as a condition of your release. Don't go into businesses that sell alcohol for use inside, such as bars and taverns. Do not engage in any assaultive, threatening, harassing, or intimidating behavior towards any person while you are on bond All right, so you are in one of those unique positions, Mr. Peltola, where you have come before the court for your arraignment. Already behind you, or what you're being arraigned on, is both the underlying charge and a bond violation. So usually people will have an underlying charge and then whatever, week 2, 3 later, they come back with a bond violation. And when people are arraigned, I always give them a talk and tell them that if you come back with a bond violation, you're going to make it really hard for me to say, gee, I should let you back out into the community again. You, however, have not had that talk. You are having it today, and you are having it on both the underlying charge and the bond. So my pep talk is this, Mr. Peltola. I'm going to set the bond accordingly and give you the benefit of the doubt. But if you come back in here with another violation, I'm going to say, gee, Mr. Peltola, I had the talk with you, and you went out and did the same thing I told you not to do. So I'm telling you, don't violate your bond and make me have a reason to keep you in custody pending resolution of your case. I'll set your bond right now at 1,000 PR. That's on both the bond violation and the underlying charge. They're going to let you back out, Mr. Peltola. Don't go back out and start drinking and do this again because, like I said, you'll leave me no choice. All right?
Oh, Your Honor, honest to God, I'm not even on drugs anymore. I wasn't sick. The only reason.
Hold on.
Nope.
I can see Miss Anderson almost doing cartwheels back there. She does not want you to talk until you have a chance to talk to your lawyer. Is that right, Miss Anderson?
That is correct, Your Honor. Thank you.
All right, Mr. Peltola, do you understand? She wants you to talk to your lawyer before you tell me anything, all right?
Yes, I understand, Ms. Lacoste, or Judge Lacoste.
Thank you, Mr. Peltola. We will see you soon. Your bond will come over, your writing dates, your lawyers. Make sure you call her when you get out and, you know, have a meeting with her. All right, Mr. Peltola?
Yes, Your Honor.
All right, anything else on this file then, Miss Anderson?
No, thank you, Your Honor.
All right, thank you. Have a good day, Mr. Peltola.
This virtual court hearing turns into a fascinating collision between internet-born legal theories and the unshakable structure of the real justice system. Appearing by video from the Dickinson County Jail, Drew James Petu enters the hearing with a calm but confident tone, clearly prepared to present himself in a way that sets him apart from the typical defendant. Right from the start, he signals that he does not view himself through the standard legal lens, identifying instead as a non-citizen American national, and referencing common law concepts that courts have consistently rejected. But this case carries an unusual twist that immediately changes the dynamic. He is not alone. Sitting in the legal space beside him is an actual defense attorney, Abby Anderson, who is formally representing him. That single detail creates a quiet tension that runs through the entire hearing. On one side, you have a structured courtroom process built on statutes, procedure, and precedent. On the other, you have a defendant expressing identity-based legal beliefs that exist largely outside recognized law. And in the middle stands a lawyer whose job is to protect her client within the real system, not the theoretical one. The judge keeps the proceeding grounded, moving steadily through the purpose of the hearing. The court is dealing with a misdemeanor disorderly conduct charge along with a bond violation. These are not abstract philosophical matters. They are practical legal issues with consequences tied to behavior and compliance. While Petu uses language that suggests he sees himself as operating under a different legal framework, the judge addresses him the same way the court addresses every defendant, clearly, directly, and with procedural focus. As the discussion continues, Petu raises questions about how he should be addressed, referencing terms like human and sui juris non-citizen national. It's the kind of language often heard in sovereign citizen circles, where identity phrasing is believed to carry legal power. But the courtroom response is subtle and telling. The judge does not argue ideology. The judge does not debate philosophy. Instead, the court proceeds as if those labels change nothing, because legally, they don't. The system continues forward, unmoved. Then comes a key procedural issue that highlights the gap between belief and law even more sharply. Because Petu travels between Michigan and Wisconsin, the judge requires him to sign a waiver of extradition as part of his bond conditions. This is a standard safeguard. It ensures that if he fails to appear or violates bond terms across state lines, the process to return him to court won't be delayed. From the court's perspective, this is routine. From Petu's perspective, it directly conflicts with the identity framework he's asserting. Yet the requirement stands, underscoring a central truth of the hearing. Courtroom authority is not determined by personal legal theories. As the bond discussion unfolds, the tone becomes more serious. The judge grants a $1,000 personal recognizance bond, meaning Petu does not have to post cash up front. But that freedom comes with strict behavioral conditions. He is ordered to consume no alcohol, use no non-prescribed controlled substances, submit to random drug testing, avoid bars and taverns, and refrain from assaultive or harassing behavior. These are not suggestions, they are enforceable conditions tied directly to his release. What's striking here is the contrast. While Petu speaks in the language of sovereignty and status, the court speaks in the language of conduct and accountability. One side discusses identity, the other discusses actions. And then comes the moment that shifts the energy of the room instantly. Near the end of the hearing, Petu begins trying to explain his situation in his own words. It seems like an attempt to present himself positively, maybe to show improvement or responsibility. But in doing so, he says something that lands with immediate legal weight. He mentions that he is not even on drugs anymore. It's a statement that might sound harmless in everyday conversation. In a courtroom, it's something very different. Those few words imply past drug use, information that could potentially be used against him depending on the circumstances of the case and bond terms. Within seconds, both his attorney and the judge interrupt him. The interruption is quick, firm, and protective. It's a live demonstration of one of the most important realities of the legal system. You don't talk your way out of problems in court, you can very easily talk your way into them. His lawyer's reaction shows exactly why legal representation matters. While Petu's personal beliefs guide how he sees himself, his attorney understands how every word on the record can carry consequences. That brief exchange becomes one of the most powerful lessons in the entire hearing. Not about sovereignty, not about legal labels, but about the danger of self-incrimination and the difference between speaking freely and speaking safely. As the hearing wraps up, the structure of the system stands unchanged. Court dates are set, conditions are imposed. Procedures move forward. The judge remains calm, measured, and consistent throughout, never escalating, never debating ideology, simply guiding the case through its legal path. In the end, this hearing becomes more than just a routine court appearance. It becomes a snapshot of a broader phenomenon playing out in courtrooms across the country. Individuals bringing alternative legal beliefs into a system that operates on established law. And it shows, in real time, how that system responds, not with argument, but with procedure. not with philosophy, but with process. Most of all, it shows how quickly a single sentence can change the direction of a moment in court, and why, when legal consequences are on the line, words matter more than people think.